All right, welcome everyone. Hey, it's Clint Coons here. And in this episode, what I want to do is I want to talk about land trust. So if you're joining us, we're going to be going into the different ways in which you can utilize a land trust for your investing. If you have any comments, go ahead and throw those questions out there. You can hit me up and I'll try to respond to as many questions as I can within the hour. And so we can get through, as much material as possible. So, what is it about? Actually, let me just check one thing before we go any further here, because on my end, sometimes I can't see everything that you're all seeing, so my screen just shut down. All right, so there we go. So anyhow, what I want to do is go through the land trust and how it all comes together. So what is a land trust, and why would you ever consider using it? You see, a land trust is it's a document, okay, that's not registered with the Secretary of State. It's not registered anywhere. It's a common law trust is one way to refer to this type of entity. Now, some states have enacted statutes that recognize the land trust, but by and large, most states do not. And so we often refer to the land trust as a grantor trust. And we do that because the person that's setting it up is a grantor. That is, if I created a trust, it's a grantor trust. I'm the one creating it. I'm typically going to be the beneficiary of that trust as well. So how does this trust come about? What does it take to create one? Really, it's quite simple. All you need to do is draft a trust agreement. And that agreement, I've read land trusts that are a page long, and I've seen land trusts that, like what we put together, that could be upwards of 30 or 40 pages in length. But you just need to get the essential provisions in there in order to create a document like this. And so essentially what you need is you need to have a trustee of your trust. And that can be an individual, can be an entity that's going to be the trustee. Oh, I see that I don't have my iPad up here. You could have a individual or like I said, an LLC as a trustee. Okay, so here's an LLC. And so the trustee is going to be one position. And then down here, you're going to have the beneficiaries. Now, the beneficiaries initially, when you're setting up a land trust, are going to be the property owners. So if I own a house and I intend to place this into a land trust, then I would be the initial beneficiary. And the reason why we oftentimes set up our trusts with the property owner right here as the beneficiary of the trust is because when you deed the property into the trust, a county may ask to see a copy of the trust agreement. And the reason they do that is because they want to verify that it's not going to be a taxable transfer. And so we have to turn this over. California is a great example of that, where if you transfer title into a land trust, the assessor's office will then ask us for a copy of the trust agreement. And what they're looking for is to ensure that the beneficiary is also the owner of the property, that these two are the same parties. Now, not all states do this, but oftentimes this is how we'll go about creating the trust, just to ensure that that doesn't come about. So anyways, you create this trust and you put it together, and you get your trustee and you got your beneficiary set up. And the terms of the trust are going to govern how those assets are being held for the benefit of the beneficiaries. So one of the primary reasons why individuals like to use land trusts is for privacy. And so when you're setting up the trust and you're naming the trustee, let's say we call this the Green Frog Trust here. All right, so if I wanted to transfer property from Dave into the Green Frog Trust, I'm going to transfer it to the trustee of the Green Frog Trust. We're just not going to say, Dave hereby grants the following real estate to the Green Frog Trust. It's actually going to go in to the name of the trustee. So if you want anonymity for a land trust so that when somebody looks at title, they're not going to see your name listed on that trust. And of course, that's a benefit right there. If somebody's looking up title, they no longer see your name. They'll assume that you don't own it. But where people can screw this up is they think that the trustee is some uber magical provision inside of a trust, because we've heard about trust before where the trustee controls everything and you want to be in control. Well, the problem is that when you're setting up the trust in this manner, if your name's on there and you transfer the real estate into your name as trustee, people are going to know it's you. And so what we recommend is that you use a nominee trustee as your trustee, which means you use a third party or maybe even use your own limited liability company. And so that concern that many people have about transferring real estate into the name of a trustee. So for example, if Dave, we set up a trust and said Clint, trustee of Green Frog Trust, for example. Let's say we did something like that. Well, if I set that type of trust up and I told Dave, hey, transfer the property into Clint as trustee of the Green Frog Trust, Dave's going to assume, well, Clint, you're going to kick me out of the property. You could rent the property out, collect the rents. You could live in the property. Well, that's not the way it works, because when we create the trust, I won't have any control over that trust agreement as its trustee. And that's why it gives people the confidence many times when they're setting these things up. If they want to use a third party like myself or another attorney, you no longer have that concern that they're going to be able to step in and do things for do things to your property, because all the powers regarding the property itself are in the hands of the beneficiary. So you write this up like a contract. For example, if I was going to buy your property from you and I specified in the real estate purchase and sale agreement that you needed to do X, Y, and Z, right? Well, then in order for that deal to go through, I expect the seller to fix this and replace part of the siding on the east side of the house. Those things all are necessary. We contract for those. Well, the same thing with a land trust. It's essentially a contract. And when you're putting it together, the trustee is given certain powers under the trust agreement. And whatever powers the trustee is not given, the remaining powers sit down here with the beneficiary, and that's where Dave is. So when you're setting up a land trust, what I'm explaining to you is that you can use a nominee trustee. So when title gets taken, you'll show up in the chain of title as Dave initially, but then it'll show up as Clint Coons, trustee of this trust going forwards. And so if somebody's looking up Dave's name, they won't see that Dave's the current owner of this property. And if they look at the property itself, they'll see that Clint, as trustee of the trust, is the current owner. And so they think that I'm somehow the owner of this property through the trust. But the reality is Dave is that owner. And the reason why people can't figure this out is because the trust document itself is not recorded anywhere. The trust is not set up with the Secretary of State, so you have to disclose any information. It's a private document. The only way you know this trust even exists is because title to the property is held in that trust name. So once that's done and it's created, if you're using a nominee trustee, then that nominee trustee shall resign their position. And when they resign, again, this all happens behind the scenes, then Dave steps in as the new trustee. So if you wanted to do this and you wanted to create a land trust and deed your property into the name of the trustee and set all of this stuff up, then you want to make sure that when that trustee resigns, if you're using a nominee trustee, that the trustee provides you what is termed a trustee's deed. Now, this is where I've seen a lot of real estate investors run into problems. They set up a land trust and they use a third party as their trustee. The trustee resigns and appoints them the beneficiary, but nothing gets recorded, all right? Because if you recorded the fact that I resigned and Dave's now the trustee of the trust, then that just kind of blows all the anonymity there. So what we want to do is give a trustee's deed from Clint to Dave. And so it's an actual deed form that I would complete. And it says Dave's now the trustee of the trust. Why would I do that? Because if Dave ever needs to refinance a property, wants to sell the property, he's going to have a hard time selling property in a trust where he's not listed as a trustee. Now, he could eventually probably get it done, but it's so much simpler if he has a trustee's deed in his hand from the resigning trustee that he can take and record at any time. So all he has to do is go down, record the document, and he's good to go. His name will now appear there, so he has apparent authority over that trust to take any action. So that's one way the trusts are set up with Dave as trustee. The other thing that people use is a limited liability company. We've been doing a lot of this lately where we'll set up a Wyoming LLC as the trustee of the trust. So you don't have to use myself or a third party. You have your own LLC set up, and when the LLC is set up in Wyoming, remember your name doesn't appear anywhere on that Wyoming limited liability company. New Mexico is another state that people use. You're completely anonymous. So we just list the LLC name now down as trustee. And then you don't have to go through this trustee resignation stuff that you would if you're using a nominee trustee. So you have two options. If you want privacy with your land trust, appoint someone that you know, trust, or is a professional, an attorney, as your initial trustee, have them resign, and then you step in as the successor trustee, no one knows. Or you should use a limited liability company in Wyoming or New Mexico or some state that doesn't collect any information on you. So if somebody looked up the trustee LLC, your information is not associated with it. So you get this property set up here. We set it up in a land trust. And my property's in there and I'm listed as the beneficiary. No one knows about this. What do I do now? Well, the first thing that you do not want to do is stay there as the beneficiary unless this is a personal residence. Because in a land trust, with the exception of Florida, that's the only state where you have protection. If the tenant is injured and somebody sues this trust, they're going to blow right through the trust and bring the beneficiary into that lawsuit. And if we're talking about investment real estate and we want asset protection, then you definitely don't want to stay on the trust as its beneficiary, because if something goes wrong with the property, you are personally liable. So what I would recommend you do is you set up an LLC. Now this is outside of Florida. Florida, you can leave it as is, because in Florida, if somebody's sued, it stays here and it doesn't escape. You can't sue the beneficiaries. Florida law provides for that type of protection, but that's only limited to Florida. So in my example with Dave, after the trust is set up and the property's funded into the trust, Dave will then transfer his interest through an assignment to a limited liability company. So he will then step out of the picture and he'll make his LLC the beneficiary. Again, like I said, this document's not recording work. No one knows about any of these transfers. It's purely private. The reason we're putting it into the LLC via the trust in this manner is that, again, if something happens here, then the liability rests here. I don't want it resting on your shoulders. So this is how you will provide asset protection for your land trust, or for you when you own property inside of a land trust. You want to make sure those trusts get assigned over to the LLC. Now, what I run into on occasion with individuals, they'll ask me this question: hey, can I put multiple properties in the same land trust? The answer to that is yes, you can. But that's like putting multiple properties into the same limited liability company. If something goes wrong with this trust right here, then all of these properties are at risk. So what is your risk tolerance level? Do you want to do that? And people will then oftentimes respond back on the comments, oh, no, that was stupid. I didn't mean put all of their properties into one land trust. What I wanted to do is create 3 land trusts with 1 property each and have those 3 land trusts owned by the same LLC. Well, again, there's no difference as far as asset protection is concerned if you put 3 properties here or you put 3 properties into the same LLC. Because if there was a concern, what would happen is somebody's going to sue this land trust, right? So here's my concern. My trust is under attack. They'll then be able to come down into the LLC because the beneficiary is liable. And if they get a judgment against the LLC for $200,000, they can then go after any assets that are held on that side of that limited liability company. And if there's 2 land trusts that are in the name of the LLC, that is, the LLC is the beneficiary of these trusts, then they can take those interests. So what you've essentially done with 3 land trusts, another way to conceptualize this is to do this. You've got 3 properties in 1 LLC as follows. So therein lies a problem. If you're looking for asset protection, you want to separate out your liability exposure. What you should really do then, if you're using land trust in your investing, is to set up a relationship where you have trusts to separate LLCs, just like this. So now the liability just stays in its one channel and it doesn't spill over to the other side. Now, Patty, you're right. I was just going to go there. What she asked is, what about the Series LLC? So if you live in a state that recognizes a Series LLC, what I would do instead of having separate LLCs is I would put up one parent limited liability company. All right, so here you create your series parent, and then you create cells, just like this. And you put each of those trusts into a separate cell. The cells are going to give you the asset protection that an LLC would, and then all the cells are owned by the parent as follows. So there's different ways to put this structure together, and the idea is we want to isolate the channel. So if anything goes wrong, it's only that one property, that one cell that's at risk, or that one limited liability company that's going to be at risk as a result of that lawsuit. So what are some common scenarios where people use land trusts as real estate investors? Because this is what comes up a lot. You've heard about a land trust. You've been told this is a must-have tool for all investments. And I don't necessarily adopt that strategy. It's like anything. It's not a one-size-fits-all. You really need to know what you're doing and then determine whether or not the tool that we have, or the tools that we have available for us, which is the most appropriate one for that technique, that investing technique that I'm engaging in. Now, it used to be probably, say, 15 years ago, we would oftentimes tell people, hey, if your property is encumbered by debt here, and you're concerned about the due on sale clause, and you want to move your property directly into an LLC, deed it directly in, but you think the lender might accelerate your note, well, to minimize that risk, you should use a land trust, deed your property into the land trust, and put your land trust into the LLC like I just showed you. That concern has been pretty much eliminated or minimized for most people, because right now you have QM or qualified mortgages, or you have non-qualified mortgages. And so as an investor, if I'm going down the QM route and I'm going to be working with something that's underwritten by Freddie or Fannie, their guidelines permit us to transfer properties directly into LLCs. We no longer have that concern that we did 10, 12 years ago. Now we can put them directly in. If you go the non-QM route as an investor, they don't care how you take title, right? I mean, in that instance, they'll let you close in a limited liability company or even a land trust, whatever you'd like, because they're going to charge you a higher interest rate to be able to do that. Excuse me. So that previous concern that we used to have about the acceleration clause really doesn't hit my radar that much anymore. What I'm looking for now when I'm using land trusts, the first reason I'm using them is for transfer taxes. So if you were going to transfer real estate into a limited liability company, and the transfer is going to be a taxable transfer in your particular state, take Florida. That's a classic example of this. If you have debt on the property and you want to transfer property into an LLC in Florida, you're subject to the dock stamps. It could be a couple of grand in order to transfer property directly into an LLC. So instead we use a land trust. And there's many other counties across the United States that we prepare deeds in, where when the client wants to put the property into an LLC, we'll tell them, you could do that, but if we did that, there's going to be a tax on that transfer, because your county will tax any transfers from you to a business entity. But we can get around it by setting up the land trust like I showed you, and transferring it to the land trust and putting the land trust in the LLC. So transfer taxes, that's typically the first concern that I have when we're looking at the use of a land trust. So should I use a land trust, yes or no? Well, if you can go directly into the LLC, most times I'm going to tell people go directly into the LLC, don't use a land trust. Now, another situation that comes up is when we have an individual that wants to transfer real estate out of a limited liability company. For example, I will oftentimes see investors who are looking for asset protection, and they've made this mistake. They've put 4, 6 properties inside of one LLC. And why did they do that? Well, because they just didn't know any better. They thought all you need to do was create an LLC, but then they realized after working with Anderson that a better strategy is to have separate LLCs for each of those properties, like this. But the problem we face is if we try to transfer the property from here to here, that's a taxable event at the county. Or we transfer the property from here to here, That could be a taxable event with the county. More importantly, if we were to do this, transfer it from here to here and then here to here, that's 2 deeds that need to be recorded. And the issue there is that you're going to see that chain. It goes from LLC to Clint, from Clint to a new LLC. So one strategy that we like to use in this scenario, if you came to us and you had multiple properties into one LLC and you want to break everything out, I would suggest, hey, let's create 6 land trusts. And then what we're going to do is we're going to deed each of the properties out of the land trust to their respective LLCs like this. So you have one deed that you have to record, and that is from the LLC to the land trust. Now the land trust holds title to the property. So what we're going to do after that step's done is we're going to take each of these land trusts and put them in individual LLCs through an assignment of interest. So we're able to get to this position where we have much better protection, and we did it in a way which eliminated any potential transfer taxes we would have had if we went directly to the LLC or down to us, and we minimized the number of deed filings, and we've actually created some anonymity and a lot of confusion for a potential creditor that may be coming after us. So this is where you would consider using a land trust strategy if you have one entity that has several pieces of property in it and you want to break them out. Now, before you go about doing that, also keep in mind that how that entity is taxed. If that red box that I just showed you was set up as an S Corp or a C Corp, you definitely couldn't do what I just showed you. That strategy only works when that red box is either a partnership or a disregarded entity. Okay, so that I'll call that one, that's called the multiple property transfer, is when we will use land trust in that scenario. Now, another scenario where I like to use them is if you're going to buy at auction. So if you're going to buy at auction, then you may want to consider using land trust. So I'll give you an example of one of my clients down in Texas. He buys a lot of properties at auction. And what he wanted to do initially is he wanted to create limited liability companies to use at auction. But the question was, how many LLCs do we need to create in any one time in order to make sure he has sufficient number of entities on hand when he went to auction? So I proposed we use a different strategy. I said, how about if we set you up with a land trust? And so I gave him a template, a land trust template, and we filled it all out where he was listed as the initial beneficiary on his land trust, and we set it up with a limited liability company as the trustee of the trust. So he has this template. He would print off 4 or 5 and he'd bring them with him to auction. And then when he would find a property that he wanted to bid on and he wins the bid, let's say he got the property on 121 A Street. Okay, that's the property he wins. What he would do is he'd pull out the trust document that he has right there and he'd put on there 121 A Street Trust, okay, with his LLC as a trustee. Now, this particular style of land trust that we provide, it's a 2-page land trust. So when I say print them out, just 2 simple pages. And so this is the way this client, well, actually we have several clients that do this. They bid on the properties, they take title in this trust initially. Now, this trust, it doesn't have all of the provisions that we want to see in a land trust, but it's good enough for him to provide it at auction so he can take title to the property. Once that's done, and he has that property under the name of this trust, what we do is we restate the trust, which means we draft a new trust that has all the necessary provisions, that's much greater in length. You know, now we're talking about a 30-page document that replaces this existing one. Because land trusts, you can amend and restate them at any time. So they're freely changeable. So we'll just change the trust. And then once we've redrafted the trust the way we want it, we put the beneficial interest into a limited liability company. No one knows about this. It all happens behind the scenes. And so this is the way a lot of my clients who buy at auctions tend to acquire property, because it makes it easier for them, because they want the property in the name of an entity that has that property's address on it. And if you're setting up LLCs, you know, you have to keep coming up with multiple different LLC names. You want them to somehow relate back to the property you're buying. The best way to do that is by using a land trust. All right. Now, here's a question here that comes up quite a bit. John wants to know if my property is in a land trust, free and clear, can I ever refinance it while it's in the land trust? Okay, yes, you can. John, you can refinance a property when it's in the name of the land trust. You can close in the name of a land trust. So here, I'll give you an example of that. Last week, one of our clients, we set up a land trust. I'm listed as the trustee, so Clint's on here as the trustee. My client's the beneficiary of this trust. We closed on the name of a piece of property. He bought a piece of property. He wanted to close in the name of the trust. Title sent a notary here with all the closing docs for me to sign as a trustee. So I signed all the documents as the trustee for closing. I then resigned my position and I named my client the successor trustee of this trust. So on public record, it shows Clint Coons as trustee of the name of this trust. Now, in December of this year, similar situation, I'd already established a land trust for a client several years ago, and it holds their personal residence. Now, I had resigned my position, just like I showed you here, probably 8 years ago, and my client and his wife were listed as the trustees, but not on title. So they wanted to refi this property, do a cash out refi, and pull out $750,000. And mind you, they're beneficiaries of this. But they didn't want their information to be listed on the title to the property. They wanted to maintain their privacy. So how do they do it? They called me up and I said, here's what we need to do. You need to reappoint me as your trustee. So you resign, put me back as the trustee. I'll accept that position. And it corresponds with how title read at that time. It reads Clint Coons as trustee. Then you contact your lender, start your refi process. So I think they worked with Mellon Bank and they started their cash out refi. Again, title, they sent out a notary. Mellon Bank the notary came here with all the closing documents and I had to sign off on all the closing. I didn't sign off on the promissory note, but I agreed as trustee that the trust and its assets would be liable to the lender in exchange for that loan. So I signed all of that information on behalf of this trust. And then they paid out the $750,000 cash out to my clients through the trust. After that deal was done, I resigned my position and I reappointed them as the successor trustees. So you can structure it in this manner as well. So the answer to that is yes, you can refinance property. Now, let's assume that you can't find a bank that's willing to do what this bank did for yourself. Okay, so in that case, what you need to do is take that trust. I told you earlier, you can take a land trust and you can convert it at any time to any type of trust you want. So what I would do here is I would convert my land trust to a living trust. Done this before for our clients. Why am I doing that? Because if I'm going to a bank and I'm getting a cash out refi, it's going to be a Freddie Fannie type loan. If they see a land trust document, if they're the attorney, an underwriter that's reviewing the trust document, because they're going to ask for a copy of this, if they see that it's a land trust, then they're probably not going to do the deal. Now in this case over here, this wasn't Freddie Fannie product, so it was not a QM deal here. In this case, if you're doing that, then you can't send them a copy of your land trust documentation. They will decline it to do the deal because Freddie Fannie will not buy loans where a land trust is the holder of the property. They'll only buy the loans in those situations where it's an Illinois land trust or a Florida land trust. So what you need to do is you change your trust. It's called a restatement. You just draft a new simple living trust document. It says, if something happens to me, it goes to my spouse and then to my kids. And so you draft this, you sign it. It has the same name. Everything's the same. You send that to the lender. You get the deal done under the living trust. And then once you've got your refinance done, then you convert it back to the land trust. In fact, on my channel, I think it was last year or the year before, I interviewed an attorney that actually works with underwriters and lenders, and he reviews trust agreements as they come in, And I got to know him through a situation where one of my clients was doing this, because they said, no, we won't accept the land trust. I said, hey, how about if it looked like a living trust? He goes, hey, whatever you send across to my desk, as long as it meets what's required, that's all I need to see. So we restated it as a living trust, deal went through, then we reformed it back to a land trust. And so I actually interviewed him about that transaction. So you can check that out. It's on my channel, my YouTube channel. All right, so that's how you would handle a situation like that. Now, another question came in here. Sean wants to know, I live in California and I have rentals in Arizona and Tennessee. Can you discuss if there are any benefits of using a land trust versus a Wyoming statutory trust for any of my rentals or my California residence? All right, so the idea is, should I use a land trust for my residence? Well, that's another reason why I recommend you use land trust, and that is to provide protection for your personal residence. So what I would do in your scenario is I would set up a land trust here for my California residence. Excuse me, I do it like this, and I would either have, myself, if we were setting it up as your nominee trustee, or a Wyoming LLC as your trustee. Now, some of the times the problems you run into in using a Wyoming LLC as a trustee on a land trust for your personal residence is with the insurance. You may run into some issues there, depending on where you live, on obtaining your homeowner's insurance, because they see an LLC as a trustee. It really depends. So I would set this up as follows, because for my personal residence, I want anonymity, meaning I don't want people to know where I live. So by moving it out of my name and putting it into the land trust with a nominee trustee or with an LLC trustee, if somebody looks up my name, they're not going to see me registered with any particular property any longer, because I'm not listed as the owner of any real estate. So that is a strategy for a personal residence. And also the benefit is that if you get a judgment against you individually, that judgment that is recorded against you in the county where you reside won't stick to your personal residence, because if your personal residence is not in your name, any judgments entered against you won't attach to that property. Personal judgments only attach to the real estate that you own, that your name appears on. And the strategy right here, your name no longer appears on it. So if you wanted to refi or sell, you could sell as long as you held title in the name of that trust, and the creditor would not be paid. Whereas if I had that property in my own name and I tried to refi or sell, then the creditor is going to get paid. So land trusts work great for the personal residence. But what about those properties in Arizona? You said, should you use a statutory trust? And the reason why this question is relevant to this individual who asked it is because they live in California and there's a tax on LLCs. So what I would do in that scenario, rather than use land trust, I would suggest you set up a Wyoming statutory trust right here. And then for Arizona, I would create an LLC. And for Texas, depending on how many properties you have, I'd probably use a Texas Series Llc like this and have them owned by the Wyoming statutory trust. The reason I would do that is because in Arizona, you couldn't take title in a statutory trust without disclosing who's the beneficiary and who's involved with it. You have to record the document. So it doesn't make sense to use this vehicle there. You could use a land trust and then have it held by a separate statutory trust. But I think a simpler approach is just create the statutory trust. It's not subject to franchise tax in California, and then have it own LLCs, therefore making those LLCs member managed by the statutory trust. And then these would be exempt from the franchise tax as well. So I think for California, this would be a simpler approach to the overall protection that you're looking for. All right, what else do we have here? Are these transfers done through a deed to a trust? James wants to know. Do we transfer these via deed? Yes. Whenever you transfer property into a land trust, you will use a deed, but do not use a quitclaim deed. Use a warranty deed when you're transferring the property in, because a quitclaim deed will let anyone know who pulls the title records that you're still somehow involved with that trust, because no good faith purchaser for value would ever accept a quitclaim deed from a seller. So it would, I know that the only people that use quitclaim deeds are related parties. And if it's your trust, or it's a trust that your name doesn't appear on, I know it's your trust, because there's no way else you could have set that transaction up with a quitclaim deed if someone was buying it, because you would never accept a quitclaim deed from a seller. So it's pretty obvious on its face. All right. So when else would we use a land trust? Subject to deals. So subject to transactions is one area where this is a popular tool. And if you're not familiar with what a subject to deal is, that is a situation where you have a property owner here who has this house, and you're going to approach them and say, listen, I want to buy your property, but I'm going to give you a little bit down. So I'll give you $10K down, and then I'm going to take over your mortgage. So you're going to remain liable on the mortgage. Okay, but I'm going to pay it for you. So that means subject to. I'm buying the property subject to the existing financing. So I don't have to use my credit. I don't have to get a loan from the bank to put this deal together. So when you see subject to investors, that's what they're doing. Now, the concern for this investor or the property owner many times is that the bank might call the note due. And the reason why is that oftentimes these types of motivated sellers have fallen behind on their mortgage or behind on their property taxes. So the investor over here that is coming in to buy the property, they're buying it for $10K, but they're also, bringing the mortgage current and reinstating the property taxes, bringing those up to making those current as well. And so the lender may be looking at what's going on with this seller. And we don't want to convey to the lender that, hey, the seller's actually transferred this title to a third party. So what investors will use is a trust as follows: to transfer the property into the name of the trust with the investor as the trustee initially, and the client as the beneficiary, and then the client, or the seller that is, and then the seller transfers the beneficial interest over here to the investor. Or another strategy I've seen done is where the investor is the beneficiary and the seller is the trustee. Then the seller resigns and gives a trustee's deed to the investor to be the trustee. So the investor controls the property. So there's different ways to set this up. But the whole purpose of using the land trust in the subject to deal is that it lessens the likelihood that a lender is going to think that something's going on, that there's actually been a transfer of the real estate to a third party, and diminishes the likelihood that they'll accelerate. Now, that is the argument, and that's why I've many clients that utilize this tool to put together their subject to transactions. I personally think, though, it's probably better to use a limited liability company here. I don't think lenders are going to accelerate. They just want to collect payments. They don't care who the owner is. And excuse me, by using the LLC, the seller, they're familiar with LLCs. There's a less likelihood that they're going to think you're trying to pull something fast on them, and there's less education that you have to concern yourself with to bring the seller up to speed on how you want to structure the deal. So I think the LLC is a cleaner way to do this, but that is one way in which people have used land trusts over the years, is to invest in these subject to deals. All right, what else we got here? So, you use a deed to a trust when you transfer the property between the different trust types: land trust, a living trust, and back to the land trust. Okay, so when I said, Jules, about transferring the property back and forth, what I meant was this. You create your land trust here. Okay, we'll call this the 1, 2, 3 trust. Then when I want to convert this to a living trust over here, I'm going to create a new trust, and it's going to be called the 1, 2, 3 trust. And what this trust is, it's a restatement. So what that means is that on title, originally to the property in the land trust, it said the 1, 2, 3 trust dated 1/1 of 21. The new trust that I create, the living trust, will be the 123 trust dated 1/1 of 21, even though I signed it today. You know, here we are in 2022. It's May 12th. So when I sign this trust, I'll say it's May 12th, restated on May 12th of 2022, but the trust title will remain the same. Title will always be held in the 123 trust dated 1/1 of 2021. So when we go back to the original land trust formula, we're going to restate it again. And this will be the second restatement of the 123 trust dated 1/1 of 2021. So there are not multiple deeds that are happening here. The initial deed went into the trust. Once it's there, you can keep changing the terms of the trust as you go forwards. Sometimes I cut a video regarding Turo car sharing, and this is one of the things I said. I said maybe you start with when you're going to do your car sharing to hold title, you start with a living trust. That's what you provide when you're asked by the bank about how you're taking title. You use a trust, and then you convert it to a personal property trust. For if you were into car ride sharing, and why is that? Well, because if you're going to a lender or leasing company to finance a vehicle, they're not going to want you sharing this car out with somebody else. In fact, the terms of the agreement state you can't. So if you take title in the LLC or a business entity, that's going to throw the whole deal off. So you use a land trust or a living trust, which they're accustomed to. It's your estate plan, but your living trust can change into a land trust or personal property trust at any time because you reserve the right to amend it. So that's why I like trust, is that you can change the character of these things just by changing the language. It's not like an LLC. When you set up an LLC, it's going to be stuck in that form. You can't take an LLC and say, you know what, tomorrow I want it to be a corporation. Instead of having membership interest, I'm going to have shares. It doesn't work that way. An LLC is, I would say it's rigid in that it's set up in a certain manner, and you have to stick or stay consistent with the statute. A trust has far more flexibility in your planning. Okay, so Hal wants to know, why not just buy leased commercial property with Wyoming LLC as the buyer, and then Wyoming LLC uses a third-party property manager and deposits rents in the Wyoming LLC and local bank? Okay, Hal, your question, a little off topic here on the land trust, but I think what you want to know is that if you had a property right here in a Wyoming limited liability company, so this is my Wyoming LLC, and you use a third-party PM. So here's my PM. I think actually what you meant was this. You have a land trust here, so that owns the property, like this. Land trust is held by the LLC. So the LLC doesn't own the property. I believe that's what you're asking me, Hal. And so in this case, then, your property is managed by an out-of-state property manager, because this property here, let's say it's located in Tennessee, okay? And you have a property manager in Tennessee. So the strategy then, one of the strategies people use with land trusts is that if they want to set up they want to own property in a state that is expensive to set up LLCs, like California or Tennessee can be, because you have to have the fonts exemption you want to qualify under, but then you don't necessarily have anonymity. What you'll do is you'll buy you'll hold title to your property. It starts off, here's Hal, he has property. He'll set up a land trust. This is Tennessee property. He'll deed the property into his land trust. And then he'll take that land trust, because the land trust does not offer asset protection, as we've been talking about, and he'll set up a Wyoming LLC over here, and he'll transfer that into the Wyoming Limited Liability Company. Now, why would you do this type of transaction? Because if you were to set up the LLC in Tennessee, you have to do so in a certain way that requires you to disclose all your information to avoid the fonts, or not the fonts, but to avoid the franchise tax in Tennessee. So by using a land trust, it's not subject to the franchise tax. We use an out-of-state LLC to hold the beneficial interest. And the reason we're using an out-of-state LLC is because, or why can we use it, is because the LLC doesn't own the property, so it's not conducting business in Tennessee. So we're able to minimize taxes and get the asset protection of the Wyoming LLC, at the same time have anonymity. So that's how you could set it up as well. But what's key here is that the properties need to be managed by a property manager, because your Wyoming LLC can't be managing property in Tennessee. So if you have a third-party property manager handling the deal here, then what you would say is, hey, property manager, distribute the rents every month to this limited liability company. Why would I do that? So I don't have to open up a bank account for this trust. It holds title to the property, but my rents are flowing down here to my Wyoming LLC. And in fact, in this example of Tennessee, I might even make this a Series LLC in Delaware and set up separate cells. So if I had multiple properties in Tennessee, I would have different land trusts going down into each cell, pick up that asset protection of using this Delaware Series for this Tennessee's properties, rather than separate Wyoming limited liability companies that you would set up. And in that case, that would work as well to structure it that way, Hal. So yeah, you could do that. You could do that for sure if you have an out-of-state property manager. All right, here's another one. If you own rental properties not in an LLC or another form to hide ownership and have high liability insurance coverage, how can you still open a landlord to additional lawsuits? How can this still open up a landlord to additional lawsuits? Well, if you own rental properties not in an LLC and they're all in your name, Brian, and something goes wrong with the property. I just had this discussion with someone today. So he said to me, in his case, he actually had one LLC with 24 homes in it. And he said, why don't I just go out and get a high limit policy here? I'll get an umbrella policy against all these for $3 million. I said, great, but what does that do for someone that's coming after you? That's going to encourage that plaintiff to go after your assets because you got a lot of insurance there. And I don't know what that would cost anyways to get a policy like that to cover all 24 properties. I think he actually said $5 million. I said, when you have a policy with a huge premium amount, then the creditor that's coming after you knows there's a lot of money at stake, and so they become more aggressive in their approach to the litigation. Whereas if you had one property in an LLC and you had $250,000 policy limit on that, and somebody's suing you, well, how does that conversation look to that plaintiff's attorney? What I'm going to want to argue to them and say, listen, take my policy limits of $250,000 and give me a full release. Leave the property alone. Now, maybe they're not going to be willing to do that, but now you can bring pressure back, and here's how you bring the pressure back on them to get them to reconsider. You say, hey, if you don't take this deal, then I'm going to be forced to litigate, and it'll probably take us 2 years. And under my policy, there's a carve out for $30,000 of attorney's fees. After that, it starts eating up the policy limits. So 2 years from now, what you could get today at $250,000, the way my attorneys bill me, I mean, they just get 2 or 3 guys involved at one time. They triple bill me. You may only have $100,000 left in that policy after we go through trial. So even if you win, the most you're going to collect under my policy is going to be $100K because I've spent down everything else defending. And then the equity in this house right here is only $60,000. So you're only going to make $160,000. So it's either take the $250,000 today that we're willing to offer you, or let's fight it out for 2 years and take the $160,000. That gives you negotiating power when you're working with the plaintiff and they're an aggressive plaintiff. Whereas if you had a $3 million policy, they'd be like, I just want to eat, and there's a lot here to eat. And I know you're not going to spend that much in defending this case, so they'll go after it. So that's why I like using the asset protection and not just relying upon insurance. And the last portion about that is relying upon an insurance policy. How do you know that that claim is actually even covered under your policy limits? That can be a problem as well. All right. So here's a question that just came in. Now, Next year, I'm buying a house in the Dominican Republic. Can I put it under a trust? Charles, I'm not sure what the rules are down there about property ownership, whether or not you can use a trust in the Dominican Republic. If you can, great. That might be an option for you, but maybe there's a better option as well down there. Maybe it's a limitatus or some other type of structure. Something else to keep in mind, if you're going to be setting up land trusts and you're using a strategy where the land trust is held by a limited liability company like this, I like to use the same name here. So in this one, if this was Red Fox LLC, I would call this the Red Fox Trust. Keep the names the same if there's an LLC involved in the picture. Why? Because many times when I'm putting this deal together, the LLC is going to have the bank account. The land trust is going to have the property. It won't have a bank account. So back to the other example I gave you in Tennessee, your bank account's down here and the property manager is paying this limited liability company. They're not paying the trust because there's no way to negotiate that check if it doesn't have a bank account. Well, when I go to sell my property, what can happen when you sell is that the title company, through escrow, they're going to pay the property owner. So they'll write a check here to the land trust for $175,000. And so this check comes in for $175,000 made out to the name of the trust. Well, if the trust is not named the same as the LLC, you're going to need to go open up an account in that trust name, deposit that check, wait for it to clear, go back in, pull the proceeds out, go back to the bank and shut the account down. A simpler approach is to just keep the names the same, walk into your bank that you use for this limited liability company and negotiate the check. Say, yeah, they screwed up. It should have said LLC and they put trust on it. I've never had that fail me in my business. I just walk in, they'll just negotiate it through under the name of the LLC. So that's one way to do it. The second way you could do this is that you would file, if they rejected that, you file a DBA and you call the LLC Red Fox Trust. So I did this strategy in it where my land trust did not have the same name as the LLC. So I filed a DBA for my LLC, and, called Red Fox Trust, for example. So, and I provided that DBA to the bank, and I took the check in at the same time, and I was able to negotiate it to the limited liability company. So when you're setting up these things, you kind of want to think down the road that eventually, if you're going to sell, you want to be able to cash that check without causing, too much concern for yourself or too many problems. You don't want to jump through a bunch of hoops to get the deal done. All right. Jules, problem. Opening up individual land trusts for each property. Insurance company says they'll give multi-property discount because each is now owned by different entities. What is the workaround? All right, so from the insurance side, what I would recommend you do is look to a group like National Real Estate Insurance Group. They offer policies, so they'll put an umbrella over all your entities. They don't care how they're held. They'll give you a policy there. And I think the other company is Chubb. They're another group that works with real estate investors where you can buy that one umbrella policy. So that, I think, is the best option. You can add and subtract just by going onto their portal. Because really, they just assess the property. They don't care who the owner is. They'll handle it for you internally. So I think that might be the better option for a real estate investor. Brian, I live in California and in the process of buying an apartment in Los Angeles with seller financing. What is the best structure to hold title to provide asset protection and anonymity? Now, Brian, you live in California. So if you want to buy property, and you said you're using seller financing, what I would do, you have two choices. You could either use, assume it's an investment property, you could either use a California limited liability company, and that's going to be subject to the $800 a year. Or what you could do, actually you have three options. Another one is to use a Wyoming statutory trust. That's not subject to the $800 a year, and it offers asset protection like the LLC. Or you could use a land trust to buy the property and then have the land trust owned by a statutory trust like this. So you just roll back under the statutory trust. Now, why would I choose one versus the other? I'd only use this if this was a commercial property. I would only use the LLC if I was buying a commercial property. Since yours is residential, I would look at using a statutory trust for it, so I don't have to pay the $800. But the problem with using the statutory trust is we do have to register it in California, so there are some additional fees there in maintaining this structure. So rather than paying California LLC is actually going to run you more than that. It's going to run you about a little over about $1,000 a year. So the statutory trust, because you have to have it registered in Wyoming and California, is going to probably run you closer to $475 a year for that structure, versus $1,000 for this. The other option is to put the property in a land trust and then have the beneficiary of the land trust be the Wyoming statutory trust. You don't register it in California because it's not owning the property, and that cuts your fee down now to, I think it's going to be $175 a year to have the asset protection. So there's different ways you can layer this out for your overall planning. That's why I said, it's not a one-size-fits-all approach. All right, got time for a few more here. California resident can have California rental properties, is Wyoming land trust with beneficiaries family trust. Yeah, so if you live in California, you can definitely use, we just showed you, you can use the land trust, but I'd only use the land trust here for my personal residence. If that's what you're going to do, set it up in a land trust and then have that land trust held by your living trust down here. That's great, but only use it for your personal residence, because if you did this with an investment property here and something goes wrong with that investment property, then they're coming down here into your living trust and they're going after you. So for residents, that's a fine strategy. It doesn't matter where you live, California, Texas, Arizona. Use the land trust for investment property to an LLC. On the personal residence side, it can go to your living trust. That's not an issue. All right. Ryan, can you please elaborate how to finance under a trust or LLC? Which is easier to do when it comes to financing? Well, when it comes to financing under a trust or an LLC, essentially you're going to be working with a non-qualified mortgage. Okay, so a non-qualified mortgage is one in which it's not being underwritten through Freddie, Fannie. This is being sold to Wall Street, to investment institutions. And so you're going to pay more for that type of mortgage that you're going to be obtaining. And so with a non-qualified mortgage, they're not using the same, as I stated, underwriting guidelines. So they're not looking so much at they do look at your credit score, but that isn't the determining factor. What they're going to look at is many times 1 year's worth of bank statements. They want to know about cash flow. What they're seeing is whether or not you have enough money coming in to make sure that the mortgage will be paid on that investment property you're buying. They'll also look at your experience level as well when it comes to real estate investing. So when you're working with those non-QM mortgages, you can take title in a land trust, you can take title in a limited liability company. It does not matter. You'll still have to give a personal guarantee, of course, as well, but they're more flexible, and you're paying for that flexibility because the interest rates are going to be higher than a QM deal that's set up under Freddie Fannie guidelines. So that's why it is different between the two. Okay, what if you're renting property that you didn't have title to? It's under a contract for deed. Is there anything that you can do for protection? So if you don't own the property and you're renting it out under a contract for deed, well, really, you have equitable title in that property. So one could argue you would be liable. So what I would do in my contract for deed, I would have an LLC set up as the party to this deal. And then I'd be renting it out over here to the tenants. So the LLC sits in the middle. Excuse me. So if something goes wrong with the property, they're paying the LLC. They look to the LLC for that recovery. Because in those contracts for deed situations, even though you haven't paid off the entire property yet, you're still looked as the equitable owner, and you're probably listing that as such on your tax returns, and you're writing everything off, and you're depreciating the property. So I'd be wanting to get an LLC involved there to provide myself some protection. All right, got time for two more here. Good evening. I'm trying to buy a property to rent so I can pay child support. How do I protect? All right, so it depends on where you're buying the real estate. If you're and what type of financing you're using, QM versus non-QM. If it's QM, then when you go to buy that property, you have to take title in your own name. After you take title in your own name, then we need to assess where that property is located and which would be the appropriate tool in order to minimize transfer taxes, provide asset protection, and get it protected. So initially, I'm always going to start with saying, put it into an LLC. That's where I put that rental property. But if there are those factors that we covered earlier that are involved there, then maybe we first go into a land trust and then we go into the LLC. Or if it's in Florida, we just go directly to the land trust. We don't even need the limited liability company. So there's a lot that we would look at in doing this. All right. What is the typical cost for setting up an LLC and a land trust? Well, the typical fee you're going to be looking at to set those structures up is probably about $3,500 to set up that type of structure. Oftentimes we do run specials on that, and you haven't been to our tax and asset protection workshop. We have one that's next Saturday, not tomorrow. Or the following day, not the 14th, but it's going to be the 21st. Make sure you get on that event. There are things opportunities you'll have there in working with us that you wouldn't have otherwise, and you're going to get a tremendous amount of education as well. If you want to know how to join that, you can go to our website, andersonadvisors.com. You can check out the event section. You can register. It's free. It's a one-day event where we talk about tax and asset protection planning. When I say we, myself and my partner, Toby Mathis, I'm going to go through the residential real estate side, commercial side as well, how to structure those deals. And then he's going to come in the afternoon and just show you how you can squeeze every last tax deduction out of your rental real estate. So it's a phenomenal event. If you haven't made it there, seen it yet, I suggest you do. All right, great info. How about transferring your mortgage to a limited liability company after it's set up, or to the land trust? Not going to happen. Don't even waste the oxygen on calling up the lender and saying, I want to transfer my mortgage to my land trust or to my LLC. It's not going to happen. They're not going to do it. And in fact, you may stumble into something where they say, oh, you want to transfer your mortgage? Great. We're going to charge you a fee to do that. So you let that one lie. Now, some people will say this, well, Clint, if the mortgage isn't in the name of the LLC or the land trust, so you got the property on title there, but I'm still liable to the bank on the mortgage, do I have asset protection? Absolutely you do, because who's liable for the property? The owner's liable. It doesn't matter that you're on the mortgage, it's the LLC that's liable. And if you're or the land trust. So if you're doing everything right, that is collecting rents in the name of the LLC, paying the mortgage, paying all the expenses, you're not going to be liable for what goes on in that property. Another way to look at it is as follows. Let's say that your daughter wants to buy this property, but she doesn't have any credit. So you come in and agree to co-sign on that loan. You're going to guarantee the loan so she can get into this property. So you're responsible on the mortgage with your daughter. Now, if something goes wrong with the property, she's listed as the property owner. You're not listed as the property owner. Are you liable? No. You're liable only to the bank. You're not liable to any people that are dealing with your daughter or going on her property, because you don't own that property. The only person you have privity of contract with where you have liability is the actual lender himself. All right, we put the link up there to join us for the asset protection event in the comment section there, guys. If you want to join, you can just click on that link and register for it. But I hope you learned a lot. I'm going to, like I said, be on notice of this. I'm coming up with different topics every couple of weeks. We're going to be doing a live event. It's going to happen on Thursday at 2 o'clock Pacific time. And bring your questions. I know some of them are off topic. I don't care. I love that. Just I want to be able to get out there. And if you have ideas, be sure to hit me up with that. Email me any ideas you have, or leave them in the comments about different strategies or structures you'd like me to cover in my videos or topics for these events, I'd appreciate it. I wish you all the very best with your investing. Take care.